And get started. Good afternoon, everyone. My name is Don Schweitzer. I'm with Day Air Credit Union. We're glad you're here with us today talking about the home buying process. Last week, we talked about the lending process part of home buying. And this week, we're going to be talking about legal matters. Next week, we will have Jim King from Agora Realty talking to you about the buying process. So today we have Doug Sabesi with Martin Foligno Law Firm. Again, he's just going to be talking about the legal matters when it comes to buying a home. So with that, again, keep in mind that this is being recorded. I'm going to ask that you mute yourselves unless you have a question. And as always, I do have chat on. So if you have a question via chat, please do so, and I will go ahead and make sure that Doug is aware that there is a question available. So with that, Doug, have at it.
All right. Well, thank you guys for all coming. I got Vicky, April, and Marcia on my list, and then Don and Josh. Am I missing anyone? No? Okay. So as Don mentioned, my name is Doug Sabesi. I'm an attorney with the law firm of Martin Foligno. We have an office in downtown Dayton and we have an office in Brookville. My practice is focused on estate planning law, real estate matters, and business matters. So I, represent clients on, I was talking to Don about it a little earlier, primarily transactional type matters. I haven't been to court in many years and I try to stay away from it as much as I can. So again, most of it's transactional type work, paperwork, things of that nature. My kind of history is I went to UC and studied finance and real estate. After graduating there, I went to Cleveland State, where I grew up in Cleveland, and went to law school there and graduated from Cleveland State in 2003 and started practicing with the firm I'm at now in about 2005 and have been here since then. So just a little bit of history about me. Last week, Josh mentioned that I'm an engaging speaker, which set the bar kind of high for me. I wasn't sure what to do with that. A lot of times we'll present these or have these presentations for various high schools in the area. And I call it the I'm not sure exactly if that's the proper name anymore, but the home economics classes where the kids are kind of learning about finance. And one of the topics is home buying. In that sense, the buying process is a little bit further off than likely for you guys. And if this is going to be your first house, or if you're looking at, second, third, or moving up in houses, things of that nature. So, the engaging part of it comes from that back and forth discussion. This is a presentation for you all that, you can maybe learn something or get some insight that maybe someone's not told you before. So I welcome any questions and I want to make it, tailored to you as much as possible. So even though you're muted, if you have a question, chime in at any point in time, or if you have, something you want to discuss that I'm not bringing to the table, let me know. So with that, anything right off the bat that anyone's thinking about? No? Okay. So when you talk about the home buying process, I always like to refer to having a team. A lot of things you don't want to go on your own with. So home buying's not that much different. You want to have a team there to help you through the process. Don's kind of put together the outline of what that team could or should look like. And at the forefront is the mortgage lender, because they're going to provide the money that you ultimately need. Next week, you're going to hear from a realtor, which is kind of the forefront of that team, because they're going to be, finding properties for you, taking you around, inspecting them, things of that nature, where my role as an attorney is kind of in the background. If you remember last week, I sat there and watched Josh's presentation. You probably wondered, who's that guy over there? And that's kind of how I feel during a real estate transaction is we're sitting in the background. And a lot of times you may never even talk to me or need me, but a lot of the things that you're going to be going through in the buying process, attorneys are involved in. So the first kind of part of it is the contract. So I always, like to ask, how many of you have bought a house before? Is any of you bought a house, or is this going to, Vicky? Okay. How many of you have, bought something, car or bike or clothes, things like that? Everybody's probably bought something else. There's a distinction in those two purchases. You want to buy, a stick of gum or a pack of gum, or you want to buy a shirt. You go to the store, you pick out what you want, take it to the counter, pay for it, you're done. There's not a whole lot of lag time in the transaction process. You decided what you wanted, you buy it. With a house, that's not usually the case. There's a lot of steps that are involved to getting to that final process where you pick out the house, then you actually move in. So you have enough cash on hand that you'd want to go out and give it to someone and buy a house. Hands, anybody? Nope. If you did, that would probably be pretty amazing, because, I don't know many people that do, especially in the way this market is now. So, they used to say that buying a house is probably the biggest investment that you'll make. Up until about 6 months ago, I was questioning that the way the car market was, that maybe buying a car would rival buying a house. But still, I think buying a house is going to be one of the biggest investments that you make. And like I said, you generally don't have the money, cash at hand to buy it. So you're going to look to a mortgage lender like Day Air to provide you that money. So that's where that contract comes into play. We don't have a simple transaction like going to the store. With real estate, you go look at houses with a realtor, you find something you like, and ultimately you got steps until you get to move into that. So the problem with that is in between time. Let's say you find the perfect house you want and you make an offer, or you tell the seller that you want to buy it. Well, that's all in good, but you can't give them the money. You can't get to the closing or get into that house until you've done some of your due diligence. So we need to have set up in place something that's going to make sure that seller promises you that they're going to sell it. And on the same token, they're going to make sure that they want to make you buy it. So that's where we have the contract. So generally, if you're dealing with a realtor, they have a standardized contract form. I don't have the capability to do like Josh did with the documents online, but contract from a realtor is pretty much a fill in the blank form. So that's kind of the first step where the attorneys are getting involved. The Board of Realtors has prepared standardized contracts that they say, okay, these are the terms that we think are generally needed, and things that have been negotiated in other contracts and decided in court cases where there's a breach of contract, which we can get into later. But they say, okay, here's what we need. So the attorneys are involved there, but again, it's behind the scenes. Now, on other cases, and I've had a lot of these in the past couple of years, especially, where you won't have a realtor involved. You'll just have, a for sale by owner, or you'll have a transaction. There's two semi-related or related parties, and they have real estate that they want to transfer between each other. So any kind of real estate in Ohio, a contract for that needs to be in writing. So for the best example of that is, I have a case now that I just got the decision on yesterday. In this case, I had a client that had a house that he inherited from his dad. He had an individual that wanted to buy it, but didn't have the money right up front, and said, well, I want to, rent the house from you until we can get our financing in order. So they entered into a lease for the house, but they never finalized a purchase contract. They said they talked about the terms and how much they were going to pay and things like that, but there was never an actual contract finalized. Well, 2.5 years, 3 years went by, and this guy didn't pay rent for about 2 years. He couldn't be evicted during the COVID issues. So once the COVID kind of broke and things loosened up with the courts a little bit, we went through the eviction process. As part of that process, the tenant, I'll call him the tenant, filed a counterclaim saying that my client, the seller, breached the purchase agreement with him. And our argument was that there was no purchase agreement. There was nothing in writing. Any writing or any transaction for real estate has to be in writing in the state of Ohio. And he could never present even just a simple letter or, a written document that said, I'm going to sell you this house. Here are the price. Here are the terms of that sale. So we ultimately won that. My client was able to get the tenant moved out. He was able to sell the house to another party. And I would like to say everybody's happy. I don't know that that's necessarily the case, but that's, one of those important things. So like I said, you get into a contract, you want to buy something, you want to sell it, you have to have a meeting of the minds in the contract. So that contract is going to provide for, the simple things are the price, how long you're going to have to come up with that money from the bank, and then what kind of inspections you may want to do to the property, what kind of terms are going to be involved, and more importantly is what is involved with the sale. So we think about buying a house, we got a house. But then the question is, what comes with that house? Do you get the washer and dryer? Do you get the appliances? Do you get the swing set out back? All those types of things. So there's a distinction between real property, which is the land, and then the improvements, which are the house, and then personal property, which is everything inside of there. So you may go to a house and say, hey, I really like that pool table over there. And if you want that included in the house, you list that in the contract. So we've got, a contract where we say, okay, I'm going to pay this amount of money. And now you have some time until you can do all those things to get the money to do your inspections. And that time period is usually what I call the contingency period. So a contingency is something has to happen before another thing happens. So when buying a house, generally the biggest contingency is you have to be able to get financing for the house. So you've entered into this contract, which is a legally binding agreement that says, I'm going to buy the house, you're going to sell it. If you can't get owned for that house, you're tough where the seller can say, hey, you breach a contract, I'm going to make you pay me damages. So you want to have a contingency that says, I'm going to buy this house, but I'm only going to buy it if I can get a loan for it. So that's the first contingency that's kind of most important. The second contingency that people generally look for is an inspection contingency. So you go to a house and it might look, pretty on the outside, but you don't know what's hiding behind the walls. And I got a call from my nephew. Him and his girlfriend are recently graduated from college. They're about 24, 25 years old and are looking at buying a house. And they said, hey, what do you think? Is this a good deal? So we looked at the pictures online and the MLSs, real pretty. They had nice painting, nice decoration, all that stuff. But he sent me the inspection report. And in that inspection report, we got information that the foundation had cracks in it, that the plumbing was cast iron, the black pipes that you'll see, cast iron pipes. Those have a history of corroding from the inside out. They might look nice on the outside, but on the inside, it's kind of like a bad artery in your heart. It swells up and water doesn't travel through, problem. Window leaking. The roof had been repaired and not quite properly. So there was a whole bunch of problems with the house, but there was a contract that said, we're going to buy this house. Luckily in that contract, they had a contingency that said it was based on our inspection and that there's no significant problems to the house, which in this case there were. Nowadays, with the way the market is, those inspection contingencies aren't as easy to get. In the past, it was pretty much a given that the buyer was going to have a right to inspect it, and you could look at the inspection and determine, okay, we've got these significant problems, is the seller going to pay to get them fixed? Or if not, the buyer has the right to back out of the transaction. So that's, another thing that you're going to want to look for is what kind of inspections can I get? Termite inspection, plumbing inspection, things of that nature. My general feeling is not to use a home inspector, but instead to go get an HVAC person to look at the furnace and the air conditioner, to get a plumber to look at all the plumbing, to get an electrician to look at the electric, and then some kind of structural construction person, maybe it be a carpenter, something along those lines, to look at the other structure of the house and make sure that it's in good shape for you. So that's, you get to that point where you say, okay, we've got the inspection done, we've got the financing lined up, now we're ready to buy this house. So the next step where an attorney would generally come into play is the title inspection. So you all probably own cars, is that right? Raise hands. Yep. So for a car, you have a paper title that you have that shows that you own the car. A house has a similar title, but it's called a deed. So the deeds are recorded with the Montgomery County Recorder's Office, and they're a public record. That shows everyone that's owned a piece of real estate for, back to the time that it was recorded or it was processed through the county offices. You don't necessarily have to have the original of that deed, but instead what happens is every time that someone buys or transfers real estate, a new deed is prepared that gets sent to the recorder's office, and then there's a chain of title. So once you have the contract in place, you'll go to your lender and they would do their due diligence, like Josh had talked about, make sure that the property's worthwhile for the amount of money that you're wanting to pay and that they're willing to finance for that. And part of that process is the lender is going to contact a title insurance company. So that title insurance company generally has an attorney on staff, and if not, they're owned by an attorney, and they'll do a title and provide a title report. That title search is going to look back through the history records and make sure the property that you're buying is owned by the actual person that's selling it, number one. And then number two, that there's not any other liens or encumbrances on the property. So when you get a mortgage for the property or a mortgage loan, that has two pieces to it. One is the promissory note. That tells the bank or the credit union that you're going to pay them back. That's your promise to them. Well, that mortgage lender is going to say, we don't trust just your promise. You might lose your job, you might go bankrupt, you might die, and we might not get our money back. So we want to have some security for this loan. We want to be able to, take the house back through a foreclosure if we don't get paid by you. So that other part of that mortgage loan is the mortgage itself, which is a lien on the property that allows the bank to collect from the house in the event that you don't pay on that promissory note. So that title company is going to look and make sure what kind of mortgages are there, that it's going to get paid off at the closing. If there's any other liens, there could be a mechanics lien. So let's say the owner had a problem with their furnace and they had someone come out and fix their furnace, and that furnace repair person didn't get paid. They have a right to file a mechanics lien, which says, hey, we didn't get paid by this homeowner. If they says we want some money to get paid, and if it doesn't sell, we can file a foreclosure and make the house be sold by a sheriff's sale and get paid for not doing the work. So that title company is going to look at those liens, those mortgages, use probate estates or deaths. I have a case going on right now where our client passed away, didn't have any family, so we are serving as the executor or administrator of his estate. There was a home equity loan on the house, and we didn't have any cash on hand in the estate to pay for that. So while the estate was pending, it was open and we were appointed as administrator about 8 months ago. We just didn't have any money to pay that home equity line. So as the case progressed, the bank said, well, we're going to foreclose on that mortgage for that home equity line. And now we have a buyer for the house and we were set to get paid for that sale, but there was a pending foreclosure. So the title company looked at it and said, okay, we have enough money from the sale to pay off the line of credit. So that mortgage is going to go away and we'll be able to transfer clean title to the new buyer. So that's where the attorneys are involved. And again, another aspect where they're involved, but you probably don't see them. When you have that title search, the title company is going to offer you title insurance. So title insurance, like any other insurance, is going to provide a payment or protection from any kind of claims that involve the title to a property. So the title search should determine if there's any problems. It may miss something. There may be a problem that's not in the chain of records with the recorder's office that the title company or the title searcher is not going to be able to see. So that's where that title insurance would come into play. So kind of a real life example of that is I had a client 5 or 6 years ago, bought a piece of property out in Xenia, kind of a rural area, but their house as well as the others. Their fence line abutted up to what they call the lane for the farmers to get their equipment back to the field in the back. Little did we know that their property line wasn't really where the fence was, but it extended into that lane. My client got a little upset and said, hey, I have more property here than I actually knew. I want to move my fence out into that lane. Well, when they moved their fence in that lane, then the farmers couldn't get their equipment back to the farm anymore. So they started fighting about that. It turned out that there was actually a claim for that lane made years ago by a different farmer. And so that's where the title insurance company said, okay, well, that should have been a record. We're going to defend you against that claim. And they paid for the defense to fight the farmer. And my client was able to get all their property without having to pay for that defense. They didn't lose the part of their property that was in that lane. So title insurance is important for those aspects. The bank is going to get a mortgage loan. The bank is going to require that you pay for title insurance for the mortgage owner, for the credit union, or for the bank. That's called a lender's title policy. They'll also offer you a purchaser or owner's title policy. They're two different policies, two different costs, and protect two different parties. So that mortgage lender policy protects the bank. If there's a claim, they pay the bank back, but they don't protect you. The owner's policy protects you if someone makes a claim and wants their property back. Another example of kind of where a claim could come into play is in probate estates or in estates. So let's say that grandma had a house and she had 3 kids. One of them died before her. And when her estate went through the probate process, only the 2 kids that survived were named. Well, legally, all 3 kids and hers would have a right to that property. But if that 3rd child who was deceased but had children wasn't named and their kids weren't named in that process, they might get left off a title. Nobody would really know that. So John Smith comes out of the work and says, hey, I'm the grandson of Mary Smith. I'm actually a 3rd owner of this house. That title company would come and say, okay, that's the case. We're going to pay you the money that you should have been paid from the house sale and protects you as the owner from having to pay John Smith that money. So that's, part of where the title company comes into play. The kind of second part of where the title company would come into play is at the closing. So you go to the store, you buy your shirt, you buy your gum, your candy, whatever it is. You probably feel comfortable saying, okay, here's the money for this item. You're going to give it to me. You can walk out of the store. With a house, how many of you are going to say, okay, I'm going to give you $100,000, $200,000 and hope you give me the deed to that property? Any takers on that? No. Marcia, you did that? No way. All right. I didn't think so. Probably at a typical purchase, like, you know, household goods, things like that, is about the extent. Even if you sold a car, it'd be not a very good idea to say, okay, here are the keys to the car, here are the title, before you actually get the money. With a house, you're definitely not going to do that. Most likely there's not a, okay, here's the money that we're going to allow you to, before you get the deed to that property or the keys to that. So there's a closing. In that closing, the title company will generally act as the escrow agent. So they're going to be the third party intermediary. They're going to say, okay, we're going to get the money from the lender. We're going to get the deed from the seller. And there's documents that you have to sign. Again, that promissory note and that mortgage, all the disclosures that you have to sign with the sale, things of that nature that have to be signed before the escrow agent says, okay, we're satisfied that this transaction is complete. We're going to give the seller the money. We're going to give the buyer the deed and the keys to the house, and everybody can go on their way. Those are, again, the background items of where attorneys are involved. There's some issues when we have problems where we kind of step out of the background and say, okay, we're here to help you. One of the biggest would be a breach of contract. So like we talked about, the contract is saying that I'm going to buy the house, you're going to sell it. Sometimes we have an issue where you say, okay, I want to buy this house from you for $100,000. Seller signs a contract and says, that's a good deal. Well, you're doing your inspections and another party comes up and says, hey, I really like this house. I want to buy it for $125,000. Well, that seller might say, okay, I'll take your $125,000. And they're going to try selling it to that third party. If that is the case, then you have a breach of contract and you'd want to get a lawyer involved because there would be an issue with the lawsuit. You might sue them for what they call specific performance, making the seller sell that house to you and not to that other party. Another remedy or solution to that would be that you'd get damages. So you lost the house for $105,000. Now you have to go find a new house that's comparable and you have to pay $115,000. That seller might have to pay you some money for that. Another issue that comes up with that contract is, again, you have where you say, I'm going to buy the house for $105,000. You're going to sell it to me for that amount of money. That seller might not feel real comfortable just taking your word for it. So they want to have some earnest money or a deposit. Generally, like Todd said, or Josh said, you're going to put down $500 or $1,000. That's a deposit where the seller says, okay, if you don't buy this house, instead of me having to get my own attorney and sue you, I'm just going to take your earnest money. Well, if there was a reason, maybe one of your contingencies why you backed out of the sale, then there's an argument about who gets that earnest money, and that would be handled by attorneys. The other things are getting into the contract. You have disclosures. So any home that was built before 1978 has the potential for lead-based. So a seller needs to provide a lead-based paint disclosure telling you that this house was built before 1978. There could be lead-based paint. If that disclosure is not provided, there's an issue with potential damages if you find there's lead-based paint in the house later on. The most common and the most problematic is the real property disclosure. So the real property disclosure is required by sellers in Ohio to be provided to buyers. That disclosure tells any buyer of any known defects or what they call latent defects in the house. Those would be things that only the buyer would know that the seller may be not able to identify just by regular inspections. So a good example of that is the case that I'm working on right now. I had a client buy a house and they received a disclosure from the seller that said, this house is really good, it's dry, there's no problems with it. Well, my client moved in December 31st. January 1st, we had a big rainstorm. They went down their basement, the basement was flooded. Looked around and said, you know what, this isn't unusual. There's a watermark behind this drywall wall where this had flooded before. There's some dirt in the corner where the sellers had furniture stacked up and they never let us go in that room. So we initiated a claim against that seller and said, hey, you guys never told us about the basement flooding. You knew about it because you hit it with furniture stacked up corner and you painted these walls so that we wouldn't be able to see it. And we were able to get some money for the buyer for that case because they didn't provide that disclosure. I say that disclosure is, when I'm representing sellers, I tell them not to provide that disclosure just for that reason. Is people like to use it as a warranty that says, oh, well, we're telling you nothing's wrong with this house. And then after they move in, something goes wrong with it. And the buyer says, hey, you didn't tell us about this. Well, my seller may not have known about it or may not have thought it was an issue. And so if they provide that disclosure and don't disclose it, it becomes contentious. Whereas if you don't provide the disclosure, the remedy for that is the buyer has the right to back out of the contract all the way up until the closing date, which in a lot of cases, if they've gone through the steps to buy the house, to get the lending in place, they're probably not going to do that. So those are, some of the things that happen there. Let's see. I got a couple of notes. Let me see if we kind of covered everything. Going back to the closing, when we have that closing, there's going to be typically prorations on the closing price. So if you've agreed to buy a house for $100,000, you don't owe just $100,000. Those numbers may change based on, like Josh had said, any prepaids that the lender is going to require you to pay. So you might have to give the lender some money so that when insurance comes due, they pay it. Real estate taxes, you might be aware in Ohio, real estate taxes are paid in arrears. So every January and every July, homeowners get a bill from the county for the real estate taxes. Those bills they receive are actually from a year prior of the house ownership. So when you get the bill in January, that is from January through July of the year prior. You go to close, you're going to pay taxes the next time you get that bill, and those are from when the seller owned the house. So the seller is going to provide you a credit on your purchase price. So if you bought a house for $100,000, taxes on that house are $5,000 a year. Let's just say you close on July 1st. In Montgomery County, it's customary to prorate real estate taxes on what they call the short form proration, which kind of brings up a good point. A lot of real estate transaction practice is customary to the area that it's in. So for example, Montgomery County, like I said, does a short form proration. Most of the counties surrounding us, Greene County, Preble County, Hamilton County, those things, they do what they call a long form proration. So the seller owes the buyer taxes for the full 6 months that they're going to pay, plus a prorated period from the day they sell the house to the day the last tax payment was paid. So it ends up being, however, let's say you buy a house on February 1st, you'll the seller would pay you 30 days from January 1st through February 1st, plus a full month, 6 months of taxes on that proration in a long form proration county. Also the fees that you pay. So like that title inspection fee in Montgomery County and most of the counties here in the Southwest Ohio, it's customary for the sellers to, for the buyers to get their own title inspection and determine that the sellers are who they are and that they have proper title for the house. In the northern counties of Ohio, it's backwards. And for a lot of commercial transaction, it's backwards. In those counties, it's customary for the seller to pay for that title inspection or to provide title insurance. So you'll want to talk with an attorney or talk with a realtor to know what the customs are in the area that you're looking and to know what kind of things that you actually should be paying for. Kind of looking at my notes here, see if there's anything that I missed. I think that covers about, the extent of what we have that's involved when we have a realtor. Like I mentioned in the beginning, that's involving a realtor. When a realtor is not involved, an attorney will generally prepare their own contract, because we have to have that contract to begin the steps for the lending or begin the steps for the title inspection. The contract is kind of the heart of the transaction. It's going to detail everything and it's very important. So if you decide, hey, I found a friend that has a house they want to sell me, an attorney can help you out with the contract, walk you through those steps, buy a term life insurance policy for the term of my mortgage, so that, maybe $100,000 or $200,000 term life insurance policy might be $20,000, $30,000 a month, depending on your age, health, and all those type of things. Right. And then if you die, that would pay off that mortgage. Then it becomes a question of kind of estate planning. Okay, who do I name as the beneficiary on that life insurance policy? When you buy it through that lender, generally the lender is naming themselves as the beneficiary so that the mortgage is paid off and there's no questions asked. Right. And in my scenario, and my recommendation is you say, okay, I want to leave this house to my spouse, or I want to leave this house to my kids. Then you name that child or the spouse as the beneficiary, and they have an option. Okay, I'm going to get X amount of dollars, which should be equal to what's left on the mortgage. Do I want to go pay off the mortgage, or do I want to keep that money and just keep paying the mortgage? Things of that nature.
Okay.
Yeah.
All right. Thank you.
No problem. A lot of times credit cards, will have those too. It'll pay off the balance at death. That's more standard, like as a benefit to the card. Whereas on the mortgages, it's something you in almost every event, I've never seen it where it's free. You pay for extra.
Yeah. Okay.
There's also, and I can't remember if Josh talked about it, but there's also what they call private mortgage insurance, or PMI. So most lenders in residential real estate will require you to have 20% down. So if you're going to buy a house for $100,000, the bank's going to only lend you 80% of that purchase price, or $80,000, without having to pay PMI or private mortgage insurance. And then once you reach that 80% loan to value, then you don't pay that mortgage insurance anymore. For example, when my wife and I bought our house, it was in need of some significant repairs, and we knew we were going to put a lot of money into it right away. So we said we want to have that cash available to do those repairs. So we had a loan that was, I think we ended up putting about 5% down and paid PMI for about 5 or 6 months, knowing that, okay, after the 5 or 6 months were done, we could refinance and get to the levels that the the mortgage company wanted without having to pay the PMI. So a lot of that is, financial discussions that you'd want to have with, Josh or your mortgage lender.
Hey, Doug, let me add something here about PMI. PMI only insures the lender, Marcia. So if you had a loan with PMI and something happens that you couldn't pay, it wouldn't insure you. It would insure the credit union only, or the lender only. Just wanted to add that in there.
Oh, okay. Thank you.
So are any of you actively looking for houses now? No?
At least not right now.
Okay. That's probably a good thing, the way this market is. I had a client that had a house. Again, like I said, I do a lot of probate work, and came to me and said, well, we got mom's house, when should we get a realtor and things of that? And I said, well, you're going to have a garage sale this weekend. Why don't you just stick a sign out there and say for sale and see what happens? He said, all right. Well, that was on a Friday. He came back in the office on Monday and said, well, the house is sold. I got someone that came at the garage sale and they want to buy it. So, and I'm satisfied with it. That's all well and good. But as you'll learn next week, you have the realtors that are there to tell you, hey, is what you're paying a fair price? Is this a good house for the location? Things of that nature. So there's times when you may want to go it alone, but most often I tell clients, hey, get an attorney or a realtor involved for those things that you don't know about.
Okay.
So Doug?
Yes.
How are the ways you can actually title a deed?
Okay. It's a good question. So if you're an individual, you own the property individually. If you have more than one people, there's what they call joint tenants. So there can be what's called a tenants in common, where let's say me and my brother, we each own a house. We own 1/2 interest in that house. It's in what they call an undivided interest. So it's not that I own the upstairs and he owns the downstairs. It's that we all own half of the whole. The significance to that is, let's say I die or I want to sell my half. I can sell it to anyone I want. He has no say in that. Or if I die, I can say, okay, my wife gets my half interest and now her and my brother are owners of that house. What's more common with spouses is they have that joint tenancy, but they have interest in the house. But if one of them dies, that half interest automatically transfers to the other owner. And that can be with spouses, or that could be with unrelated parties, or whatever the case may be, but it has to be created at the same time. So if you're buying a house, you would want to have that survivorship interest at that time. Yep. Marcia, do you have a question?
What you just said, how do you get that set up? You got to go through an attorney, or?
So on an existing, let's say I own my house now. Me and my wife let's say I just bought it. Let's say I bought my house before I was married. Then we got married.
Okay.
To set up that survivorship interest, I would sign a new deed from myself to myself and my wife. And that deed would say, so it'd say Doug Sebesi as grantor grants to Doug and Cindy as joint tenants with rights of survivorship. So I'm transferring the house from myself to myself and another party. So I guess maybe to ultimately answer your question is, yes, you would contact an attorney to prepare a deed for you.
Okay.
And then once you sign the deed, then it would get recorded, and then that would create that.
Okay. Thank you.
Mm-hmm. Now, kind of a little bit of a twist to that is, and part of that isn't necessarily, it's while it's real estate related, it gets more into the estate planning realm, which you kind of find as I'm talking, you probably have interpreted as a lot of those things are interrelated. So let's say again that I bought the house before I was married, or even I bought the house after I was married. I was the owner of that house, but I don't want my wife to own it for some reason. Let's say, she's a teacher, but let's say she was a doctor or even a teacher. They have, liability issues out there. And you might hear about this a lot with doctors, that they have liability issues, that they don't want to own the house because if they get sued for malpractice, then they could lose their interest in the house. So what you would do is I buy the house, I'm the owner, but then I could prepare what's called a transfer on death affidavit that says, okay, I own the house now, but if I die, I want it to automatically transfer to this other party. And now we don't have to go through the probate process. Doesn't matter what my will says. Doesn't matter if I have any other heirs. Or let's say, again, I own the house and I want it to go to my brother, not my wife. I name him as the beneficiary, and then my wife doesn't get the house.
Oh, okay. Now, say, for example, because I did that with our family house, that it'll transfer back over after my death, will go back to the other siblings. Right. That's what I did on mine and transferred on there. But it was something you said about not having like your name or something on there. How does that, what that example you gave about, let's say the doctor didn't want his name. Okay, but how does that feel legally, your portion of the property?
In that case, it wouldn't be. So let's say the husband is a truck driver and the wife is a doctor, and the husband owns the house. The wife is not the owner. So she doesn't have rights. It wouldn't matter. Now, there's an archaic rule called dower rights in Ohio. So
it's called what?
Even dower rights, DOWER.
Oh, okay.
Yeah. So and it's kind of a convoluted legal theory, but the basis of it is that even if you're not an owner, but you're a spouse of an owner, you have rights to the house or the property that they own. Kind of the simple reason for that is because you can't totally disinherit a spouse in Ohio. So if I have a will and I say I leave everything to my brother, and I say in our will, I don't want my wife to have anything. When I die, or if I die, she can go to the probate court and say, I'm electing against his will, and I want my spousal support and my rights as a spouse. And depending on the family situation, if there's kids involved and whose kids they are and things like that, the wife gets up to $65,000 of assets for support. And part of what they're entitled to is what they call the mansion house, or it's really just the personal residence of the decedent. So because you don't know what that is, it's really any real estate that spouse has dower rights to it.
Any other questions? I don't see anything on the chat.
Hopefully I was engaging enough and lived up to Josh's expectations.
It was engaging. I got some good information.
And I don't know if Don had it for you guys, but if you wanted, I can give you my email address if you had questions that you didn't want to ask here, or needed more information. It's pretty simple. It's Doug, D-O-U-G-S, like Sam. So there's multiple Dougs, at Martin, M-A-R-T-I-N, Folino, F as in Frank, O-L-I-N-O.com.
Okay. Well, thank you.
Anything else? All right. Well, thank you, Doug. I really appreciate you sharing the information. You